All right, good morning. Welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Demetris Benson. Keith Solis Brown. Laquandre Colon. Marquandre Daquan Colon. Tammy Crocker. Michelle Daly. Michelle Lynn Daly. Nicholas Duncan. Bobby Jordan. Max Juarez. Looks like Mr. Juarez is appearing via Zoom for Sanctions Court. Gavin Lambino. Jordan Manning. Guy McSpadden. Lena Price is set for sanctions. We're resetting her to May 15th. Isaiah Rosser. Isaiah Jabrar Rosser. David Shields. Caleb Waller. I believe Mr. Waller is set for sanctions today and he's in the Clinton County Jail. We're going to remove that from the docket at this time. Kendrick Willis. Here. Ronnie Callahan. Here. James Godwin. Motion for continuance was filed by Mr. Hawkins that was granted, approved by the court. We've reset that for, I believe, plea on May 15th. Is Mr. Godwin here? Did Mr. Godwin appear? I ordered him to appear, sign a notice of reset, and a check-in with pretrial release. Did he not? Has he not appeared to you, Mr. Abraham? Sean Allen. Stephen Martinson. Yes. Michael Patterson. Justin Yeager. Jace Quaid. Charles Bell. Gavin Gonzalez. Here. Marty Hedden. Here. Wesley Ball. Here. Lemmy Brandon. Joshua Brown. Here. Carrie Criswell. James Fontenot. Here. Joshua Huffman. Joshua Stephen Huffman. No. Let me my office. I believe you get. Okay. Kimberly King. Yes. Kip McNinch. Here. And Jeffrey Smith. Here. All right. Is there anyone whose name's not been called? You expect to be on the docket today? All right. Do we have any attorneys that are ready?
Judge, may we approach Gavin Gonzalez?
Yes. Mr. Gonzalez, if you'll come forward. This is cause number CR 24-208, State of Texas versus Gavin Lane Gonzalez. All right, Mr. Gonzalez is set for pretrial today. The court having discussed pretrial issues with the attorney for the state, attorney for the defendant, the court will reset pretrial hearing to June 10th at 9 a.m. Once Mr. Gonzalez gets his notice of appearance, he's free to go.
Yeah, if you have it. Yeah.
Charles Bell. This is cause number CR 24-298, CR 25-1, State of Texas versus Charles Kenneth Bell. I believe we're set for pretrial. Go ahead, Mr. Wilson.
Yes, Judge, no motions, and we're just going to proceed to docket call. If the state and I have been talking, we just got to meet again.
All right, there being no contested pretrial motions, the court sets Mr. Bell for docket call on June 10th. That'll be at 9 a.m. And once Mr. Bell signs, he's free to go. Did he get his notice of appearance, Mr. Wilson?
Yes, we got it here, Judge. Thank you.
You are. Mr. Thorson, you ready?
Yes, sir.
You ready on Mr. Quaid?
Yes, we are.
Mr. Quaid, if you'll come forward. This is cause numbers CR 24-222 and 223, State of Texas versus Jace Dale Quaid. Show that we're set for docket call today. Mr. Thorson, go ahead.
We are, Your Honor, and this case, there is a companion case, and there's a suppression issue that's at the Court of Criminal Appeals that we're kind of waiting on a decision on to address disposition in this case. I guess if we could have the next docket call or put it on a contested docket awaiting the resolution of that, I think we're in agreement about that. I do think this case will reach a resolution either way without a jury, depending on.
There's a companion case that he's under indictment for. That's a
No, it's a co-defendant.
co-defendant, and it's already up to the CCA.
Yes, Your Honor. It's
It's not that case, Your Honor. It's another case that would have a bearing on both of these two cases.
yes,
Case that this defendant or the co-defendant are.
No, sir.
right, Your Honor. And so, yeah, if we could set this kind of for a status on, I don't know if we carry it on the contested docket, just for status on that case. I think there's a fair chance that it could be dispositive.
Do you know what the calendaring looks like for that case up on CCA?
Your Honor, I want to say that there's supposed to be some movement on it in the next couple of weeks. But it was only granted discretionary review, I think, in January. So I haven't seen much of an update on it, but I think I remember that there's supposed to be some movement on it in the next couple of weeks here.
Okay. All right, Mr. Thorson, how about June 10th?
Sounds good.
All right, court sets Mr. Quaid for docket call June 10th in each case. Once he signs, he's free to go.
We need separate forms in both.
No, you can just write the cause numbers at the top.
Okay, thank you.
Are you? You, Mr. Barrett?
Yes, sir.
Okay, that's fine.
Thank you.
I need to grab a pass. Yeah. Okay, thank you so much. Let's see.
They're right here.
Oh, they're right. Thanks.
Are you ready, Mr. Barrett?
I am, Your Honor.
Okay.
Mr.
Mr. Callahan, if you'll come forward. This is cause number CR 25-5, State of Texas versus Ronnie Liddell Callahan for pretrial. Mr. Barrett, any contested pretrial motions the court needs to set for hearing?
No, sir, Judge, this is actually my first appearance. We waived arraignment. I would just ask for a second pretrial if that's possible.
What's the reason for a second pretrial?
Well, or whatever the court would like to set
I mean,
it.
have you received discovery?
I haven't yet.
Your Honor.
I haven't. Go ahead.
Yeah, sorry to butt in. We're working on getting portal access for Mr. Barrett. We've spoken this morning about how to make that happen quickly. So he has not received all the discovery in this case, only I believe a PC affidavit. So we're working on resolving that.
What was the reason for the delay from waiver to today?
Your Honor, it's my fault. I didn't realize I had to actually call Stephanie Abney, so I will do that. But we can set it for whatever the court would like. I don't anticipate there'll be any contested pretrial motions.
All right, I'm gonna set Mr. Callahan for pretrial June 10th at 9 AM. And Mr. Callahan, have you met with the pretrial release officer yet and signed your conditions of pretrial release?
Did you meet with an officer that told you what the conditions of your bond are or not?
Yes, when I was being arrested.
No, I believe that you met with Mr. West behind you. Look at Mr. West. That's the pretrial release officer.
Yeah.
Those are the conditions that you filled out. Those are conditions that you have to comply with. If you violate those, the court could revoke your bail, put you back in jail to the conclusion of the case. You understand?
Yes.
Okay. All right. Once you sign your notice of appearance, he'll get the yellow copy, Mr. Barrett. The white copy will stay here.
Yes,
You're
sir.
free to go.
Right here.
Yep. Yeah, you can wait outside.
Okay, thank you.
Mr. Manning, you ready?
Yes, Judge.
Who would you like first?
Judge, if we can begin with Mr. Yeager.
Mr. Yeager, you'll come forward. This is cause number CR 24-308, State of Texas versus Justin Tanner Yeager. For docket call, go ahead.
Judge, we are continuing negotiations in this case, and additionally, it came to my attention that we're going to need to file a motion to inspect evidence after my most recent review of the evidence with the state. So I'd ask that we can be continued on docket call for one additional docket call.
Any objections to the state?
No objection, Your Honor. Thank you.
All right, court will set Mr. Yeager on Thursday, June 12th. Docket call. 9 AM.
Thank you, Judge.
Mr. Yeager is delinquent in his pretrial release fees, $240. Is that something he's gonna take care of today? You're gonna pay all that today? All right, very well. Who'd you like next?
Judge, next, we can go on Mr. Martinson.
Mr. Martinson, if you'll come forward. This is cause number CR 25-50, CR 25-51, State of Texas versus Stephen Martinson. I show that we're set for arraignment.
Yes, Judge, we were previously set for arraignment. I did have an opportunity to meet with Mr. Martinson. And so I do have the indictments. I may just have a moment. Your Honor, Mr. Martinson's name is spelled correctly. He understands the charges against him as well as the range of punishment. He pleads not guilty and requests to be set on the pretrial docket.
All right, the court finding that Mr. Martinson has waived the formal requirements of arraignment, enters his plea of not guilty into the record. The court sets Mr. Martinson for pretrial hearing on June 12th at 9 AM. Once he signs, he's free to go.
Thank you, Judge. Oh, you don't need that. Just a signature. Just defender.
Who would you like next?
Judge, next ready on Mr. Patterson.
Mr. Patterson, if you'll come forward. This is cause number CR 23-15, State of Texas versus Michael Scott Patterson. Mr. Patterson set for pretrial.
Yes, Judge, we have just received an offer on Mr. Patterson's, sorry. I have received an offer on Mr. Patterson's case. I have not had an opportunity to speak to Mr. Patterson regarding that offer in light of the discovery. If we may have additional pretrial to discuss that and go over everything in my office.
To just go over the offer.
Go over the offer as well as the discovery.
Any objections from the state?
No objection, Your Honor. Thank you.
All right, court will set Mr. Patterson additional pretrial June 12th, 9 a.m.
And Judge, at last check, I'm still waiting on paperwork for Mr. Allen for our plea this morning. But other than that, I believe I'm.
Okay. Mr. White, are you ready?
Yes.
Ready on Mr. Hedden?
Yeah.
Mr. Hedden, if you'll come forward. This is cause number CR 25-10, State of Texas versus Marty Flynn Hedden for pretrial.
Your Honor.
Where's Mr. Hedden at? Sorry, I saw another guy get up. I thought it was him. All right, Mr. Hedden set for pretrial. Go ahead.
Your Honor, we don't have any additional pretrial motions that I filed from the original three that I already filed to have no objection to. We would draw to the court's attention, and District Attorney's Office is aware of it. Mr. Heddick has another charge that is pending indictment that would be in front of this court. As far as setting it for a docket, I believe that there would be at least a chance for us to work some things out if we could do them all at one time.
Any update on the new case?
Your Honor, I was able to check and see that we have now received what appears to be all of the evidence in that case. I'll go over it with our grand jury attorney and see what his plan is as far as getting it in front of the grand jury.
All right, let's set it for docket call, either June 10th or 12th. Which one do you prefer?
10th be
Yeah.
fine.
All right, court sets Mr. Hedden for docket call June 10th. He's free to go.
And Your Honor, I believe I was appointed this morning case.
Yes, sir. That was Mr. Brown, I believe.
That's correct.
Keith Solis Brown. All right, this is cause number CR 25-68 and 69, State of Texas versus Keith Solis Brown. And Mr. Brown has been charged with burglary of a building and engaging in organized criminal activity. The court has found him to be indigent for purposes of the Sixth Amendment and has appointed the Honorable Jeff White as counsel. Have you been provided a copy of the indictments?
I have been provided a copy of the indictments. I've got them with me right now. I haven't had an opportunity to go over
Yeah, go ahead, take a moment. While Mr. White's doing that, the state will release discovery to Mr. Jeff White.
Yes, sir.
Mr. Brown.
Your Honor, we had a chance to go over both indictments. We understand what we're trying to be charged with. We're pleading not guilty in each of them, and our name is spelled correctly in the indictments.
Court will find that Mr. Brown has waived the formal requirements of arraignment. The court enters his plea of not guilty into the record, sets each matter for pretrial hearing on June 10th. Mr. Brown, have you met with the pretrial release officer, Mr. West, today to sign your conditions you have? Okay, sir. All right, then once he signs and gets his copy, Mr. White, he's free to go. Mr. Brown, did you meet with Mr. West, the pretrial release officer? Yes. Okay, you're free to go. Yeah, let's hope not. Right, you ready?
Yes, sir.
Who would you like to call up?
We called Miss King.
Kimberly King. All right, this is cause number CR 24-278, state of Texas versus Kimberly Madeline King for docket call. Go ahead, Mr. White.
Your Honor, State and I are still trying to work through this case, Miss King. This is our first docket call. If the state doesn't object, I'd ask for a second one.
Any objections from the state?
No objections, Your Honor.
All right, you want June 10th or 12th, Mr. White? Well, that's okay. Just tell me what days you prefer, like what range you looking for?
Kim, why don't we put it on? Do you have something at the end of May, Your Honor?
Yeah, I've got May 27th.
I'd like to try that date.
Try that. All right, court sets Ms. King for docket call May 27th at 9 a.m. Pretty good. Who would you like next? Mr. Ball. Wesley J. Ball. This is cause number CR 23-232. And Mr. Ball is set for final docket call. Go ahead, Mr. White.
Your Honor, we're gonna ask the court to move this over to the jury trial docket.
Okay.
As far as, I know the court will review everything and decide where to place it. I do know and feel that the state is probably gonna declare some experts. And, there's a possibility we might as well. So just letting the court know that.
All right, court sets Mr. Ball for jury selection beginning Monday, June 2nd at 8:30. Mr. Ball, on June 2nd, you'll appear downstairs. My staff will be down there. You will not go to trial that day. We'll have other trials ahead of you. You'll meet with them. Pretrial release officer will be down there. We'll give you the next setting. Mr. White's not going to be required to be there unless I notify him that you could potentially go to trial. I don't expect you to be able to go to trial on that day. So don't come into the courtroom on that day, okay?
Go downstairs.
Yeah, you'll meet with them downstairs. Mr. White, are you ready on now?
Mr. Brand,
Lemmy Brandon, CR 21-206. And Mr. Brandon is set for a pretrial.
at this time, Your Honor, I don't have any contested motions up. And I'm gonna ask the court to move this over to docket call. I did in my preparation for today, I thought of something that I needed to cross-check as far as a statement that we received. And I'd ask for leave if the state doesn't object, to file a motion to suppress. I don't anticipate it, but as an abundance of caution, we had some issues with the body cam. The state representatives worked really hard to get a copy of that for us. And anyway, I don't anticipate that. I think from a judicial efficiency standpoint, putting it on docket call would be the best thing to do, because I really don't anticipate having to file anything.
Any objections from the state?
No, Your Honor.
All right, the court will grant Mr. White leave to file late pretrial motions on that statement. For good cause shown, and also the court will set Mr. Brandon for docket call on May 27th. Connie. Mr. White, I show that Mr. Brandon's delinquent $30 on his pretrial release fees. Can he pay that today? Can we pay that today? Have you missed any appointments with your pretrial release officer?
No, sir, not that I'm aware of.
Check that. All right, so come over here and meet with the pretrial release officers, and then they'll escort you out the back when you're free to go. Mr. White?
We call Mr. Criswell.
Carrie Criswell? This is cause number CR 24-301, State of Texas versus Carrie Lynn Criswell, separate docket call.
Yes, sir. Mr. Hernandez and I are still trying to work through this one. And I don't think he will object, but we're gonna need another docket call. May 27th should be sufficient.
Anything on the state?
No, Your Honor. Thank you.
All right, court will set Mr. Criswell then for docket call May 27th at 9 a.m. Have counsel approach. All right, for the record, the court is also going to set Mr. Criswell for a hearing on his bail sufficiency. May 27th. He's free to go.
Approach.
May. What, who are you ready on next?
Mr. Fontenot.
Mr. Fontenot, okay. James Owens Fontenot, CR 24-258. All right, Mr. Fontenot is set for docket call. Go ahead.
Your Honor, as the court noted, there was an additional, there was an arrest on this case. We'll ask the court to move this to the 27th for docket call. In that meantime, I'll get with the state. We'll find out, see what we're going to do on that. And if the court wants to address the bond at that time again, as the court has indicated it was going to, we'll be ready to go.
Any objections from the state?
No, Your Honor.
All right, court sets Mr. Fontenot for docket call, and the court will consider the sufficiency of his bail due to an alleged new arrest on May 27th. Any updates on Mr. Huffman?
Mr. Huffman.
He's here.
Yes.
Mr. Huffman, you'll come forward. This is cause number CR 24-165, State of Texas versus Joshua Stephen Huffman for docket call.
Your Honor. Mr. Hernandez and I are still working on this one. We've asked for additional docket call.
Any objections from the state?
No, Your Honor. Thank you.
All right. I think this is getting a little long in the tooth, so I'm going to set this for final docket call on May.
Yes, sir,
26th.
absolutely. We'll make a note on that on the.
That on the 27th, Your Honor.
27th.
Thank you very much.
And Mr. Huffman, what time does the court start?
9 o'clock.
What time are you supposed to be here?
9 o'clock.
Why would-
Actually, 8:30 probably. Yeah, a little earlier than.
Why were you not here?
I was working with my brother-in-law. He to fire one of his employees. It was just him, so I was just trying to help him out. I was all the way in Dallas, and I was like, "Oh man," I was hurrying.
Understand? Well, Mr. Wyatt got me to not revoke your bail, so you need to be thankful to him, but you need to, don't put him in that situation where he's having to do that for you.
Sir.
All right, we'll see you back on the 27th.
Thank you, sir.
Mr. White, you still working on plea papers with Mr. McNinch?
And Mr. Smith. I've also got Mr. Brown and Mr. Mingestu still.
You ready on Mr. Brown?
Yes, sir.
Joshua Neil Brown. Cause number CR 24-255. And Mr. Brown is set for docket call.
Your Honor, Mr. Hernandez and I are still working on this case. We asked the court for last docket call on Mr. Brown.
Any objections from the state?
No, Your Honor.
Court sets Mr. Brown for docket call May 27th. All right, court calls cause number CR 24-143. This is on the court's afternoon docket, State of Texas versus Obed Mingestu. We were set for pretrial today. Mr. White showed that he is still verified in custody in Dallas County. Any updates on that? State aware of any updates from the Dallas County prosecution?
No, Your Honor, I'm sorry.
All right, court will reset Mr. Mingestu. We're gonna set him out to July. Mr. White, you available either July 8th or 10th?
Yes, sir. We can do. Let's just do July 10th.
All right, court will set Mr. Mingestu for status of custody July 10th. That's all you have on the afternoon docket, correct? I believe so. Yes. Okay. You ready, Mr. Mingestu?
Judge, I have one that I was just appointed on, but I believe he stepped out with Mr. West. You want me to grab him real quick?
Okay. Mr. Benson? Demetrius Benson? Sorry. All right, this is cause number CR 24-125. Mr. Benson, I think I reset you from the last court date to give you time to hire an attorney. Is that correct? Did you hire an attorney?
I did, but after last night, he was representing for him. I'm gonna go with a court appointment. Last night we had a,
So you hired an attorney, and then last night,
after last night, he won't be representing me anymore.
so you got your money back?
Yeah,
You act like you're not sure if you got your money back.
I mean, it was a money issue, so it's been worked out. So
Sounds very vague to me, Mr. Brown. Did you actually give money to an attorney and get them to hire you or to hire them to represent you, or did you not?
no, sir,
You didn't hire an attorney.
no, I did. He had already agreed to be my attorney, but when it got time to actually give him the money, it was the issue, so.
So you told him you were gonna pay him and then you didn't pay him.
No, that wasn't even the issue. It was so as of yesterday, when we going through everything and he gave me the bill, it was, not what we discussed, so I told him I wasn't gonna be able to pay him. Cause it wasn't, I had talked to him last month, he wasn't being with me last time, and it was different, so. Last night was the issue with it. We represent him anymore.
So how much did you pay him? How much did you pay the attorney?
No, I didn't actually give him any money.
So you never paid the attorney?
No, sir.
You just told me a moment ago you did pay the attorney.
That was the plan. He had agreed to be my attorney. And
He agreed to be your attorney if you paid him, and you never paid him.
when the guy, cause he never gave me the, like I said, when I first started last month, I came it was a different price. So this time, when it got time for me to, he actually gave me the bill for me to pay was yesterday. And it was just, you know, it was a different price. So,
You understand that hiring somebody means actually giving them money to do something? You understand that?
yes, sir.
Okay, so you didn't hire an attorney. You talked to an attorney and he said, I will represent you if you pay me this. And then
But the thing
weren't
is,
able to pay you.
he never gave me the,
I understand that.
yeah.
I understand that. I think we're saying the same thing. You asked someone to represent you. He told you, yeah. And he says, you're gonna have to pay me. You didn't know how much. He said, this is how much. And you said, I can't pay you.
You're right, cause.
So there was never a transaction where you hired someone.
No, sir.
How much money do you have to hire an attorney?
I can, I mean, I can get the money. It's like whatever amount.
So how much money do you have right now to hire an attorney?
1,000.
So you have enough money to hire an attorney, so you're not gonna be indigent. To get a court-appointed attorney means that you have to be indigent. That means that you have to be poor to a certain level that it would deprive you of your basic needs of food, shelter, and care. And that you're poverty stricken to that level that there's no way that you could afford an attorney.
Well, me personally, I can't, I would get, the money from somebody else. Like, I would have to ask somebody in my family to ask them. But
Have
me
you-
personally, I can't.
Have you already applied? Have you filled out the paperwork for a court-appointed attorney and disclosed your assets and your income and those things?
No, sir, cause like I said, until yesterday, I thought I had representation. Like literally until last night, so no, sir, I haven't.
So you were banking all along on someone else paying your attorney bill.
For right now, yes, yes, sir,
Do you work?
yes, sir.
And what kind of money do you make?
Yeah, I'm still employed, I do catering, and it's, you know, it's okay, but what's been gouging me is I'm still paying my bond to be out on bond. That's what's taking most of my money right now. You know, of course, along with, you know, other spending rent. You know,
You understand your bond company doesn't come in here and represent you on this felony charge of possession of controlled substance. You understand that?
yes, sir. So but I can't not pay them, can I?
Well, if you contracted to pay them, you ought to keep your word and you ought to pay them. But the problem is, am I supposed to just wait until you finally get enough money to pay off your bondsman and do all these other things and just put your criminal case on hold?
No, sir, that's not what I'm saying. I'm saying that, I can, like I said, I am relying on other people as far as like this, for doing this, and I'm doing my best, you know.
All right, go have a seat in the hallway. Ms. Tabraham's gonna bring you the court-appointed attorney application. You're gonna fill it out. Then once you're done, you'll come back in the courtroom and we'll have another hearing.
Okay.
Ben, you ready?
We're good, Mr. Colon?
Dave Coleman?
Yes, COLON, CR 25, 70, and 71.
Alone, okay. All right, this is cause number CR 25-70 and CR 25-71, State of Texas versus Marquandre Daquan Colon, and we are set for arraignment. Court has found Mr. Colon to be indigent for purposes of the Sixth Amendment and has appointed the Honorable Jonathan Manning as counsel. Mr. Manning, go ahead.
Judge, I have had the opportunity to go over the indictments in this, both these cases with my client. He understands, the range of punishment as well as his name is spelled correctly. He pleads not guilty and requests to be set on the pretrial docket. Judge, we would request, since Mr. Colon is coming from out of Mississippi, would ask for 45 days just to have time to get all the discovery and go over that and negotiate any potential plea offers.
Any objections from the state?
No, Your Honor, thank you.
Manny, all I have is June 12th or July 3rd. No, I'm sorry, July 10th. June 12th or July 10th.
Judge, if we can do the July 10th date, and if we get a resolution before then, I will contact the court.
All right, court sets Mr. Colon for July 10th at 9 a.m. And has he met with the pretrial release officer, Mr. West?
Yes, Judge.
Yeah. David Shields. All right, this is cause number CR 22-363. This is a sanctions court hearing for David James Shields. Let's see, Mr. Shields, you were ordered to complete your substance abuse evaluation. It appears that you've done that.
Yes, sir.
So what I'm gonna do is I'm gonna reset you for June 12th. And I'm gonna order you to do two things: pay $130 towards your probation fees. And then I need you to begin attendance to the trauma group Okay,
We discussed, yes.
okay. So those are the two things that I want to discuss.
And I'm going today, probation, and I'll be paying my probation as soon as I get there.
Very well, okay. You get all that done and then we'll be in good shape on June 12th, okay?
Yes, sir.
Here, sign this form right here.
I guess Stephanie will get with me on the date on that. Or do I
Yeah,
need to get-
if you have questions, come over here and see the probation officers. I don't have all that information, but if you want to come visit with them right now, they can
I'm
get you. to the
going
right
to
place.
probation as soon as I leave here.
Okay, go ahead.
Thank you.
Jordan Manning. All right, Mr. Manning, this is a sanctions court hearing. All right, so in our last court hearing, I ordered you to do three things, and I told you that if you didn't do them, there's going to be a day in jail for each one of them. You did your community service, your 15 hours. Where'd you do that at?
Manna Food Bank and Love of Grace Food Bank.
Say that you complied with that. I ordered you to pay $75 to probation fees. It says you did that. I also ordered you to do a $50 payment towards your court fees, and it says that you did that. So you absolved yourself of having to deal with doing jail time, so that's good. I'm gonna bring you back on June 12th. Let's go back to our next hearing. And what I need from you, Mr. Manning, is I need 15 hours of community service. Okay, I need $75 towards your probation. Okay, 10 of that's gonna be going towards your delinquent fees. And then I need $50 towards court cost, with $10 of that going towards delinquency. Okay? So those three things on June 12th, and we'll be in good shape, okay? Nicholas Duncan. All right, looks like you complied with your sanctions. You paid $100 towards your court collections, $100 to probation. That's what we're gonna continue to do, and I'll see you back on June 12th for that same thing. Okay, and I'm sure that you continue this process for a few more, there's probably a good chance you'll be getting out of sanctions court, okay?
Yes, sir.
All right, June 12th, $100 to probation, $100 to court costs. Or court collections. Tammy Crocker. This is the sanctions court hearing. All right, Tammy, it looks like I ordered you to pay $90 to probation and $100 to restitution. You've been doing that pretty consistently.
Yes, sir. I paid it on Tuesday, this the other day.
You paid both of them?
Yes, sir.
You have your receipt for that?
Yes, sir.
All right, then I'm gonna reset you to June 12th. And order the same thing, 90 to probation,
Yes,
100 to restitution. And I need you to get that done the week before.
Okay.
So that my reports can show that you're in compliance, okay?
I did it on the 20th.
You're welcome. See you on June 12th. Mr. McSpadden. Sanctions court hearing for Guy McSpadden. All right, Mr. McSpadden, let's see, on your last sanctions court, we did a 3-day jail buyback. Looks like you complied by paying your $100 to, I think I ordered you to do 120 to probation. You paid 100 and you paid 80 to your court collection. So I'll give you credit for that. What about your community service? My notes say failed to pay. The probation office has checked with the community supervision officer. They've indicated to the probation department that they don't have any hours for you.
And I was gonna tell you that I just received, because last time they switched my PO officer. Usually what happens, they fax it in from Helping Hands and it goes to a different department. My old officer was telling me, and then they put it in the system. They really don't have anything to do with it. I received a letter in my mail from my new PO, probation officer. I got a meeting with them on the 20th. Hopefully we can get it all worked out and see what's going on, because I've got where I wrote it down, but I need to make sure they're being turned in. That's the issue. Misconnections between either Wood County and the place I do it, or their offices themselves. I don't know, Your Honor, but like I said, I just got a meeting with my new officer, and I got my hours. I don't know if it's been faxed to them or not.
Tell me, how many hours did you work and where and when?
You ordered me to do 24/15, 4/16, 4/17, and 4/22.
How many did you work?
5 hours each.
All right, what were those days again?
Helping Hands in Hawkins, Texas. They're all in the same place.
All right, Helping Hands. And tell me the dates again, 4/16?
4/15, 16. I believe it looks like 17 and 22.
You said you did 5 hours each day?
Yes, sir.
All right, we're gonna try to confirm those for our next.
I'll have them confirmed for you, Your Honor, and make sure they're turned into the new officer.
All right, so we'll come back on June 12th. 120 to probation. 80 court collections. 20 hours community service.
Your Honor, on the 20 hours, it's kind of hard because of the location and getting to, I have to take a bus. It's easier for me to get 15 hours working with them because they're open 3 days a week and I only get to work certain days when I can
Okay.
catch the bus.
All right, I'll work with you 15 hours.
Thank you, Your Honor. Thank you. Thank you, Your Honor.
You're welcome. Gavin Lambino. All right, this is cause number CR 16-249, State of Texas versus Gavin Dimitri Lambino. Mr. Lambino, a motion to adjudicate your guilt has been filed. You've requested a court-appointed attorney. The court has reviewed your paperwork. The court does not find that you meet the financial criteria for the appointment of an attorney. So what I can do is I can reset this for another hearing date and give you time to hire an attorney.
That would be great. Thank you.
How long do you think it would take for you to hire an attorney?
I do my orientation for my new job Monday, so I need like at least 3 weeks until I get my first paycheck from them.
All right, say what I'm gonna do. I'm gonna set you. I'm gonna give you a little more than that. I'm gonna set you for July 3rd.
Okay.
Okay. Also, you're still on probation, okay? So just because the motion's been filed,
Okay.
you still have to report, you still have to comply.
Yes, sir.
Failure to follow those conditions, even though a motion's been filed, means that any violations, they could amend this allegation against you to include those new violations.
Yes, sir.
So continue to report and pay and do what you're supposed to do.
Yes, sir.
We're gonna bring you a notice of setting here for you to sign, have you come back July 3rd.
Thank you,
There
Your
you
Honor.
go. Bobby Jordan. All right, this is cause number CR 25-80, State of Texas versus Bobby Eugene Jordan. Mr. Jordan, you are charged by indictment with manufacture or delivery of a controlled substance of penalty group 1 greater than 4 grams, less than 200 grams. That is a first-degree felony and does carry a range of punishment if you were to be convicted and sentenced to not less than 5 years in prison, up to a maximum of 99 years or life in prison, and a possible fine not to exceed $10,000. I see that you've requested a court-appointed attorney. The court's reviewed the information you provided, and you do not qualify for a court-appointed attorney at this time. So what I can do is I can reset the case and give you time to hire an attorney.
Yes, sir.
Okay? How long do you think it would take you to hire an attorney?
At least 45 days.
Tell you what, I'm gonna order you back on June 12th. Okay? It's not quite 45 days, but it's more than 30 days.
Yes, sir.
Okay, so June 12th. And I'm gonna give you some tips on hiring an attorney, okay? So you need to call multiple attorneys until you find one that you can afford, one that you feel comfortable with, and one that practices in Van Zandt County and will come down here and file a letter of representation and take on your case. Those are all important things to talk about, okay?
Yes, sir.
All right, so if you call a Fort Worth attorney, they may not be willing to come down here. I don't want you to waste your time
Right.
waiting for attorneys to call you back after you leave a message for a week or 2 weeks, because that's just gonna eat into your time, all right? So get on the phone, call a bunch, find someone that you like, you're comfortable with, that's a criminal defense attorney. Don't hire a bankruptcy attorney. Don't hire a family law attorney. Someone that's gonna come down to Van Zandt County and represent you on this case, okay?
Yes, sir.
Mr. Jordan, have you met with Mr. West, the pretrial release officer? Okay, then you're free to go. Jermaine, you ready on Mr. Allen?
Yes, Judge.
Sean Michael Allen. This is cause number CR 24-253, State of Texas versus Sean Michael Allen. Mr. Allen, sir, it looks like you want to enter a plea today, so if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You can lower your hand. Your name is Sean Michael Allen Jr., correct?
Yes, sir.
And Mr. Allen, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work he's done as your attorney?
Yes, sir.
Do you have any questions about the paperwork that you've read and signed today that is your plea agreement?
No, sir.
Mr. Manning, do you believe your client to be competent? And if so, have you explained to him his rights as they pertain to this case? And if so, do you believe that he's entering into this agreement voluntarily, intentionally, knowingly, and voluntarily?
Judge, he is competent. I have gone over his rights in this case. I believe he's waiving those rights intentionally, knowingly, and voluntarily.
Mr. Allen, you are charged by indictment with a third-degree felony offense of unlawful possession of a firearm by a felon that does carry a range of punishment of not less than 2 years in prison up to a maximum of 10 years in prison and a possible fine not to exceed $10,000. I see that the plea agreement in your case, upon your plea of guilty, the state's recommending that the court convict you of this offense, assess your punishment at 8 years confinement in prison. The DA's office is also recommending that the court suspend that sentence and place you on 6 years of community supervision, along with a $1,000 fine, plus court costs, restitution of $180, and reimbursement fees of $535. And as part of the plea agreement, the DA's office is also agreeing to resolve several unfiled cases, including 2 possessions of controlled substance and a possession of marijuana less than 2 ounces, and you would be forfeiting the weapon that was seized as part of this offense. Mr. Allen, is that your understanding of the plea agreement?
Yes, sir.
All right, then, Mr. Allen, how do you plead to unlawful possession of firearm by a felon?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Mr. Allen, has anybody threatened you, forced you, or pressured you to plead guilty?
No, sir.
Court will accept the defendant's plea of guilt at this time. Mr. Manning, any objection to the stipulation of evidence?
No objection as offered, Judge.
Stipulation is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, thank you.
Anything further from the defense?
Judge, just that there are, I believe, some filed cases that were going to be 1245 as a part of this agreement. My understanding is that the court coordinator had those orders signed for transfer from the CCL up here. I don't know where the status of those dismissal orders are at this point in time.
But they're not part of the plea agreement, correct? That was just an agreement between you and the state? Because those are not included. There's no 1245s on filed cases. I just have 3 unfiled cases.
Judge, that was our agreement, and I believe, sorry, I'm looking real quick to see where the email was that I received. I'm sorry, Judge. I apologize. I was looking at a different set of plea paperwork.
It's okay. All right, anything further from the defense?
Nothing from defense.
All right, court's going to review the evidence. All right, the court, having considered the evidence, finds enough evidence to convict the defendant of this offense. Court will follow the plea agreement and recommendation of the DA's office. Court hereby convicts Sean Michael Allen of unlawful possession of firearm by a felon. Court assesses punishment at 8 years confinement in the Texas Department of Criminal Justice. Court will suspend that sentence and place Mr. Allen on 6 years community supervision. Court orders him to pay a $1,000 fine, $180 restitution, $290 court cost, $535 in reimbursement fees. And the court does take into consideration under section 1245, unfiled DA numbers DA 2023-1016, possession of controlled substance in penalty group 2, DA 2023-1018, possession of marijuana less than 2 ounces, DA 2023-1017, possession of controlled substance penalty group 3. Further, the court does find that a weapon was seized in connection with this offense. The court hereby orders that weapon, which is identified as a Ruger 9mm pistol, be forfeited as part of the plea agreement. Mr. Allen, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you come forward to be fingerprinted with the bailiff. After that, you'll meet with the probation officers. Hendrick Willis. All right, Mr. Willis, this is the sanctions court hearing. All right, so I'm gonna have you come back on June 12th, and I'm gonna have you pay $90 to probation, $145 to your court collections. And that's what you have to pay every month in order to expire on time.
Who's the court collections?
Right here across the hall, district court. That's for your court costs, fines, fees. That'll be across the hall here. You can also pay online, okay? So $90 to probation, $145 to the court clerk. Now you're way behind on community service.
That's because, I had 2 surgeries and I was, the doctor, I was on a
knee board, he won't be working. And I just started back work like the end of February.
So are you able to do community service?
Now, yeah, I done started back doing my community service.
Okay, so, or you do, 20 hours of community service? Cause you're delinquent 337 hours. You're way delinquent. I mean, you've been on probation for, what, 3 years now? You've only done 20 hours, and I understand if you had surgery and all those things, but what I'm telling you is if you want to expire on time in March of 2027, you got to get caught up in that community service. So we're going to start doing it in large chunks. If you were just here on regular probation, as you were, it was 10 hours a month. Now we're going to have to double that to get you caught up. Okay, so you're going to have to find some time to work and do your community service. Okay. Also, I see that you were positive for alcohol on March 11th. We did a UA test today. I see that you're negative today, but you had your interlock device removed. I'm going to amend it to put it back on based on that positive for alcohol.
I don't know what I drank to you because, I didn't want to mess up my sobriety day. I've been clean for almost 6 years.
I don't know. It just says that you tested positive. So I'm going to amend to put the interlock device back on your vehicle.
I don't know how I'm gonna do all that and pay all this.
What do you mean pay all this? These are the things that you were having to pay when you took probation.
No. Just my bills now that being behind for being off work for a year because of my ankle and all that, just I'm behind on everything. Completely behind on everything.
Well, I'm not gonna send you to prison because you're behind on your probation fees and court collection fees. You could be extended for another 5 years on probation. You've only got a 5-year term. What'll happen is if you're trying, you're just behind, I'll work with you. But I'm trying to get you caught up to where you can expire on time.
No, that's fine. I'm not putting the lock back on there. The money I gotta pay every month goes, is
So
taken away from.
that's happening. I'm putting the interlock back on there. You're gonna figure that out. Cause if they're telling me you're testing positive for alcohol and you're on probation for alcohol, then I'm not gonna allow you to be out there on your word that you're not drinking. So I'm gonna put the interlock back on there. You're gonna have to come up with a way to pay for that, figure that out. So so you need to have all those things done, on June 12th, or prior to June 12th. So, I need you to come over here and meet with the probation officers. They're gonna have you sign this form and then you'll be free to go. What'd you do to your ankle?
All the cartilage and stuff is gone in it, so they had to,
Were you like in an accident or work injury or what?
just over the years, I guess, over injuries,
Cartilage wore out between your joints?
just so they froze it where it won't move. That didn't work, so they had to go in and do a whole bunch of other stuff, so it was a bad deal all around.
All right, so we're still waiting on Mr. McNinch's plea. We're waiting on Mr. Smith's plea. Mr. Juarez, can you see and hear me okay?
Yes, sir. Could you hear me pretty well? I'm on one bar of signal.
Yes, I can hear you. We'll make this
Alright.
quick. I'm gonna order, I need you to appear in court on May 15th. That's 2 weeks.
Could
Can you hear me?
uh yes, sir. It could. Could is there any way possible where I could do the 26th or the 27th?
I'll tell you what, yeah, I'll let you do,
Just so it works with.
I'll let you do May 27th.
I appreciate that, sir. It's 'cause it's just so it works with my days off, and I get caught up on everything.
Yeah, so come into court on May 27th, because we got to talk about some issues.
Yes, sir. I will.
All right, May 27th, 9 o'clock in court, in person.
All right. Sounds good.
All right, you're free to go.
All right. Appreciate you, sir. Have a blessed day.
You're welcome. You as well. All right, this is a sanctions court hearing. Mr. Rosser, I think last time we were here, I ordered you to do a few things. One was pay your probation fees, $70, pay your court collection fees, $150, and work 25 hours of community service. My report here says that you didn't do any of those things. Is that right?
No, sir, I finished my community service and made all my payments. I have my receipts.
When did you pay those things? Like this week?
Yes, sir.
All right, so they produced this report a week before for me. So tell me when did you pay?
What?
Do you have your receipts with you? Pull your receipts out. Do you have your receipts?
Yes, sir.
Pull those out.
$150 payment, today.
Today?
Yes, sir. May 1st.
Okay. And who was that to?
Probation.
Any of the court collections?
Court.
Should have been 70 to probation and then 150 to court collections for a total of 220.
I thought it was probation, was 150. I mean, I can pay.
So it was just 150 total to court collections, and that was today. I mean, to probation.
Probation, yes, Your Honor.
All right, Mr. Rosser, this is what we're gonna do. We're gonna come back on June 12th. I need $115 to probation. $240 to court collections. 115 to probation.
Okay.
240 to court collections. Tell me about your community service. Did you work any community service?
Yes, sir. I completed my community service.
You did all 25,
Yes, sir.
25 hours?
Yes, sir. No, I did all of my 350 hours. But Mr. Marcellus said that he sent it to my probation officer. My probation officer was supposed to contact you guys.
My document says that you had 350 to do, that you'd only worked 150.
No, sir. No, sir.
You're saying that you've completed all 350 hours?
Yes, sir.
When did you complete all those?
What? Last week. 2 weeks ago. I mean,
All right, well then I'll confirm that, and then, so on the 12th, I'll address your community service. So 115 to probation, 240 to court collections. Good to go. You meet with Mr. Godwin. After you meet with him, he's good to go. Yeah, that's fine. Mr. Benson? All right, we're back on record, cause number CR 24-125, State of Texas versus say your first name, Demetrius?
Demetrius, yes, sir.
Demetrius Turner Benson. All right, the court has reviewed Mr. Benson's application for court-appointed attorney. Court is going to find him indigent at this time. Court has appointed the Honorable Richard Schmidt as counsel. Mr. Schmidt is not here today, so I'm gonna have to reset your case. I'm gonna reset your arraignment to May 27th. Later this month at 9 a.m. Mr. Schmidt will be here that day. And then, Mr. Benson, I'm going to find your bail to be insufficient today, that you violated the conditions of your pretrial release by testing positive for marijuana and alcohol.
So this is, I'm new to all this.
You've already signed the conditions.
No, I'm talking about, for the pretrial, like the marijuana in my system, that was already there before I didn't before the probation started. And then with
Where's that from?
with the alcohol, I didn't know.
Hang on, let me,
Okay.
before you dig, so you're saying that, so you signed on March 25th. Today's May 1st. You're saying that marijuana was already in your system?
So, I mean, I didn't fully understand.
I'll tell you what.
I told him that when we had our first conversation about the pretrial probation, you know, I never heard of pretrial before, and
I know, but did you not,
but even
did you
with
not
the
sign these
alcohol,
conditions?
I did, but
Did you not read them?
I did. I just didn't understand.
Does it say, don't do marijuana, don't do alcohol?
I didn't, but with the alcohol situation, I still didn't even know. Like, I didn't know how long the pretrial was gonna be. Like, I didn't know this was gonna be a thing. Like, I thought today I thought it was gonna be over. Like, I didn't know that pretrial probation was like probation like the whole time. I didn't know that. I thought that after the last time that we was gonna go to trial, I'm not even sure how all this works. And I just didn't know. I did not know. Like, I would have never had my anniversary the other day. I had a drink. I didn't know that I was still on pre-trial probation. I thought that today was going to end it, and I thought I was going to start my trial. Cause I'm not trying to fight all this. I've been working on this case for 3 years. I waited 2.5 years for a court date, and then for the bail to call me the day before, while I was out of town at my grandmother's funeral, to say I had a court date, which is why I'm in this situation in the first place. Like I never owed them any money. I always tried to get this over with. Like I lost my job behind this. That's the only reason why I'm in the situation of not being able to afford a lawyer. I genuinely didn't know. Like I didn't. I've been trying to take care of this. This happened in 2022. I didn't get a court date until last August. Like I've been trying to get this over with. I've been trying to do the right thing, go through this. I just didn't like with the pretrial stuff. I just didn't know that it was something that continued until today. Like I would have, like I would have told them the first day, like I got stuff in my system that I know it takes a while for it to get out of my system.
Not that long for alcohol.
Well, that was the alcohol was the other day. I didn't know that.
Well, you just said a moment ago that you thought it was all going to end today.
I thought it was all going to end today. I didn't know that this was going.
That means
second
that
drug test. I
you
didn't know
thought it was going to end today.
I thought the last time I saw him, I thought that was the last time I was going to see him for like a pre-trial probation. I thought that today was going to be like the trial and everything was going to be over. As far as that, I didn't know that when I came today, I was still on pre-trial probation. I really didn't. Like if I would known today I was still on pre-trial probation, I would have had a drink the other day for my anniversary. Like, I didn't know. Like I genuinely did not know. Like I have no problem with complying with whatever I need to do. I just didn't know. Like I didn't. I'm sorry for being naive and unknowledgeable, but I did not know. Like I would comply with anything, everything.
Well, you're going to get an opportunity to comply with the conditions. But you're going to go to jail today for insufficient bail. For insufficient.
I gotta go. So what happens now? Like I don't even know what's.
You're going to go to jail. You've got a court-appointed attorney. He's going to come visit with you. The attorney will work with the prosecutors. They'll try to work on your case. But these conditions are very clear. That these were going to be in effect until your case was resolved.
I didn't
listen, Mr. Vincent. Save yourself. Save yourself the trouble.
I'm
listen.
Not,
all you're doing is digging your hole deeper. Just listen. You know better than to think that conditions of pretrial release were going to end today when you show up in court and you don't even have an attorney. You didn't even hire an attorney to represent you. You came here today empty-handed. You didn't know I was going to drug test you.
I didn't know anything.
You didn't know I was going to drug test you today, and you got marijuana in your system and you got alcohol in your system. This form that you signed and I signed says that you would not do that, and you did it. So save it. Talk to your attorney. Maybe he can talk to the prosecutors about getting your bail reinstated. He'll be out there soon. I'm bringing you back here on. You can post a new bail if you want. It's $100,000. You can post that, and you can get back out, and these same conditions apply.
But even then, it's not like I'm not trying to do anything. I just don't know what's going on. I just don't know what's going on.
Okay. Well, you should ask better questions, and you shouldn't have signed this saying that I, the named defendant, upon posting the above set out bond amount, now hereby acknowledge that I have received a true and correct copy. I've read the same. I understand these conditions. I read and understand the English language, and I agree to abide strictly by the terms and conditions of supervision and release. That's the last thing you read before you signed. So.
But I understand that, Your Honor. But all I'm saying, I just didn't understand. Like even right now, like I don't even.
Do you understand now? Do you understand now?
I still don't. Like I got so many questions. I don't know what's happening. Like
Mr. Vincent, you have an attorney. I've given you the attorney that you've asked for. He will come visit you out at the Van Zandt County Jail, and y'all can work through all of this. He'll answer your questions. He'll be your representation for the attorneys of the state to work on your case. He can ask for the bond to be reinstated. He knows how to do all this. He'll explain all this to you. Where you say that you don't understand after you signed and said you understand.
No, I signed it to say I signed it that day because I was under the impression that I was up there complying. I had no problem with doing any of those things. I just didn't know one.
Then why did you go out and do them? Then why did you go out and do them? If you understood that you weren't supposed to do them, then why did you go out and do them? If you want to argue about it, why don't you give me a logical argument that makes sense And quit saying one thing and then contradicting yourself 5 minutes later. Tell me logically, why did you think that you could smoke marijuana and drink alcohol while you were on felony conditions of pretrial release for possession of controlled substance out of this court? Why did you think you could do that?
To be honest with you, John,
Think about what you're gonna say before you say it.
the day I came in, they signed that paper. Even then, when I was signing it, I did not fully understand.
Then why didn't you ask, why didn't you ask somebody?
I understood that I had to stay away from stuff I didn't, and I was.
You didn't, and you didn't.
No.
Don't tell me you did stay away from it
No.
when you test positive for marijuana and alcohol.
No, I'm sorry, y'all, I'm just trying to finish. But I didn't like the other day, like the situation, that was a while ago. Like I have not been protecting it. When I realized that I was being drug tested, I even asked him to like push back my first day so that I can get myself time to get clean, because that's when I realized. Now, when I went to go see him last time, I didn't know. Like, I'm not sure the trial process, the pre-trial process. I thought that today was going to be the day up till last with my lawyer that we just. I'm not trying to fight this. I want to get this charge off. I thought I would come today, plead guilty, so I can start my.
Without an attorney?
No, this is what up to yesterday. Before I thought I had an attorney. Like, I thought I was going here, plead guilty, and then we were just going to like go through the motions of.
Listen, I don't want you to say anything that could be used against you in court, because the prosecutors are here and you're on the record. So if you say, I'm gonna plead guilty, I'm gonna do this, I did that, don't say anything that can incriminate.
Yeah,
I'm just asking
I'm
about.
in new water. Like I said, I'm in new water. I'm not trying to. I'm not even sure wrong.
Okay,
Like,
well then we're gonna hit reset, but you're gonna go to jail today. If you wanna post a new bail, you can do that.
When I go to jail today, like, I don't even like, what do I do? Like,
You get booked in and an attorney will come and see you. He'll get notified that he's been appointed. He'll have your information. He'll reach out to the prosecutors. They'll give him the discovery on your case. If it's something that you want to resolve quickly, he can do that for you. He's a good attorney and he'll be in contact soon. All right. Wyatt, you ready? You ready on Mr. McNinch?
Yes, sir.
Mr. McNinch, if you'll come forward. This is cause number CR 24-217, State of Texas versus Kip Rost McNinch. And it looks like there is a proposed resolution today to this charge. Mr. McNinch, can you hear me okay?
Yes, sir.
Okay.
Yes, sir.
Mr. McNinch, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, thank you, sir. You can lower your hand. Your name is Kip Rost McNinch, is that correct?
Correct.
And Mr. McNinch, are you a United States citizen who reads, writes, and speaks English?
Yes, Your Honor.
Have you ever been diagnosed with a mental condition?
I don't think it's a mental condition. I have taken some pills for depression, but I don't think it's been diagnosed as a mental condition.
Okay. Are you currently on those medications today?
Yes.
Mr. McNinch, do you feel like you have rational thought and clear understanding of what's going on in court here today?
Yes.
Okay. In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with Mr. White as your attorney and the work that he's done for you?
Yeah.
Do you understand everything that you have read and signed today? That's part of your plea agreement, which is known as a pre-trial intervention contract. You've read through that. You've talked to Mr. White about that. Do you feel like you understand everything that is in that agreement and what you are agreeing to do?
Yes, Your Honor.
Do you have any questions about anything else before we go further?
No, Your Honor.
Okay, Mr. White, do you believe Mr. McNinch to be competent to enter into a pretrial intervention contract today? And if so, have you explained to him all of the nuances of the contract both in his favor and against his favor, should he violate it?
Yes, sir. I do believe that Mr. McNinch is mentally competent. I've had no issues communicating with him at all. And I went through each and all of his rights that he's waiving. I'm satisfied that he's waived those rights and intentionally, knowingly, and voluntarily. Most notably, Your Honor, as far as the waiver of jury trial and how that affects the speedy trial. Explain that to him and explain to him that in the event that he didn't complete the contract, it was going to be very, very easy for the state to prove this case up, and that essentially, if that became the situation, that the only real issue that we'd be dealing with is punishment. And I'm satisfied that he understands that.
All right, Mr. McNinch, I see that there has been an indictment returned in this case for the charge of aggravated assault with a deadly weapon. That is a second-degree felony in the state of Texas. That does carry a range of punishment of not less than 2 years in prison up to a maximum 20 years in prison should you be convicted and sentenced on that crime. Additionally, you could also be fined up to $10,000. I see that the plea agreement in the case is that you would be asking the court to allow you to enter into a pretrial intervention contract for a period of 1 year. And there are several conditions that are part of that contract that I see that you have read over and signed. Mr. McNinch, has anybody threatened you, forced you, or pressured you to enter into this contract to resolve your case?
No, Your Honor.
And Mr. McNinch, as part of this contract, you're also giving up some important rights. One of those rights is you're waiving your right to a jury trial. That means that after today, you would no longer have the right to ask this court to impanel a jury of your peers to decide whether you are guilty or not guilty of the offense. You understand, by entering into this contract, you're waiving that right.
Yes, Your Honor.
And are you waiving that right because that's what you want to do, not because you feel forced, pressured, or made to believe that you had to waive your right?
Yes, Your Honor.
Okay. In addition, you're also giving up a right, some of your rights to expunging your criminal record should you complete the contract. You've read over that, and you're also giving up your right to a speedy trial. You understand that?
Yes, Your Honor.
All right, Mr. McNinch, I would ask you at this time, how do you plead to the offense of aggravated assault with a deadly weapon?
Your Honor, since it's PTI, we're not entering a plea.
You're not entering plea? I thought we usually entered the plea and I just take it under advisement and make no finding on it and place him on the pretrial interview. Because I don't see any kind of,
Signed a stipulation of the evidence, and we waive jury trial normally.
let me review this stipulation. Is that your agreement, Mr. Hernandez, that there's no plea?
Frankly, Judge, I'm surprised. I hadn't heard that. My understanding generally, and mind you, this is probably one of the first ones that I've done. So if it's Mr. White's practice with our office to not have a plea entered, I certainly don't have a problem with that.
Okay, so you don't want him to enter a plea?
Not this time.
I thought you had explained to him that should he violate, then it would be an issue of sentencing, which means.
I did, Your Honor, because they essentially what it would become, it would be an issue of sentencing because the state had a stipulation of evidence and they're going to enter the stipulation, and that pretty much ends the trial for all intents and purposes. Because the court's most likely going to find the evidence substantiates his guilt. And of course, depending on how we would go about it in the event of that. But I've done quite a few plea of these over the years. We've never entered a plea.
All right, then the court will, so Mr. White, you do not object to the admission of the contract into evidence, which attached to that is the stipulation of evidence and the waiver of jury trial and waiver of speedy trial and waiver of limited expunction?
Not at all, Your Honor, and we understand that in the event that we did and it is in the contract, in the event that we did go to trial and he takes the stand, the contract will be entered in against him.
All right, then the court admits that into evidence. The court will review the stipulation of evidence. All right, the court, having reviewed the stipulation of evidence, finds enough evidence to substantiate the guilt of the defendant. The court will approve the contract. Court places Kip Ross McNinch on pretrial intervention contract for a period of 1 year with all terms and conditions as contained in the contract.
And I will also note, Your Honor, there's a $500 fee to go into this program. This will be paid through my office, and I just want to state that it'll be paid with an office check. I just have to get it over there.
All right, the court has signed the pretrial intervention contract. All right, Mr. McNinch, if you will come forward and you'll meet with the probation officers, they'll give you more information about your contract.
And Your Honor, if I may just supplement the record, the state is in compliance. There's a victim impact statement, I think, that may have been supplied to the court. The only request of the victim in this matter was a $75 restitution request, which counsel through his client has agreed upon.
Yeah, I did see that as an agreed term and condition of the contract.
Thank you very much.
All right, come over here and meet with them and they'll give you some more information. You, Mr. Smith?
Yes, sir.
All right, this is cause number CR 24-176, State of Texas versus Jeffrey Allen Smith. Mr. Smith, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. All right, your name is Jeffrey Allen Smith, is that correct?
Correct.
And Mr. Smith, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition?
No.
In this case, you're represented by your attorney, Mr. Nolan White. Are you pleased with Mr. White and the work he's done as your attorney?
Yes.
You understand everything that you have read and signed today that is part of your plea agreement?
Yes.
Mr. White, do you believe Mr. Smith to be competent? If so, have you explained to him his rights regarding the case, including the advantages and disadvantages of a deferred adjudication plea? And also, do you believe that he's entering into this agreement intentionally, knowingly, and voluntarily?
Yes, sir. I believe all those things.
All right, Mr. Smith, you were originally charged with a second-degree felony offense of online solicitation of a minor. The court finds today that the proposed plea agreement is upon your plea of guilt to a lesser offense of attempt to commit online solicitation of a minor sexual conduct, that the DA's office is recommending that the court consider the evidence, not convict you, placing you on 5 years of community supervision along with a $1,000 fine, $290 in court cost, and $35 in reimbursement fees. Mr. Smith, is that your understanding of the plea agreement?
Yes.
All right, then I would ask you at this time, how do you plead to the lesser included offense? Well, let me back up here. So a lesser included offense of attempt to commit online solicitation of a minor is a third-degree felony and does carry a range of punishment of not less than 2 years in prison up to 10 years in prison, and a possible fine not to exceed $10,000. So should you violate any of the terms and conditions of your community supervision, Should the state file a motion to adjudicate your guilt, should they prove up any of the violations to the court, and should the court find by preponderance of the evidence that you did violate the terms and conditions of your community supervision, that's the potential range of punishment you could be facing. Do you understand that?
Yes, sir.
Okay. Understanding all of those things, how do you plead to the 3rd-degree felony attempt to commit online solicitation of a minor?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes.
Has anybody threatened you, forced you, or pressured you to plead guilty?
No.
Board accepts the defendant's plea of guilt at this time. Mr. White, any objection to the stipulation of evidence?
No objection.
All right, the court takes the defendant's the court takes notice of the defendant's judicial confession. The court also admits the stipulation of evidence. Anything further from the state?
No, Your Honor.
Anything further from the defense?
Just very quickly, Your Honor, to facilitate this agreement, we submitted some testing from a psychiatrist to the state, and based off of the evaluation that we submitted, state had agreed to lower this down, and as the court knows, this offense is not subject to registration under Article 62. I would say that the state and I had numerous discussions about this. After a lot of consideration, that's why everybody came to this agreement that in this particular situation, based on circumstances of the offense and Mr. Smith's circumstances as well, that this was the appropriate resolution, and that in this situation, registration wasn't appropriate. However, to facilitate his probation, he will be subjected to the conditions, and I've gone over those conditions with Mr. Smith, and I understand, and I told him that probation would also go over if he had any questions, because as the court knows, and as I explained to Mr. Smith, these conditions are quite numerous, and there's a lot of technical ways that you can violate, and I explained to him that if he had questions, he needed to ask probation department, and they would be more than happy to explain it and ensure that he was in compliance.
So is it my understanding, I'm looking through them now, but is it my understanding that Mr. Smith, although it's not an offense under Chapter 62, will be under conditions that would normally address the Chapter 62 offense?
Yes.
Okay. All right, the court, having considered the evidence, finds that there is enough evidence to convict the defendant of this offense. The court will follow the plea agreement, the recommendation from the state. Court hereby defers the finding of guilt on the lesser included offense of attempt to commit online solicitation of a minor. Court places Mr. Smith on 5 years community supervision, orders him to pay a $1,000 fine, $290 in court costs, and $35 in reimbursement fees. Mr. Smith, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm going to have you come over here to be fingerprinted with Deputy Martinez. After that, you'll meet with the probation officers.